So the first time that I read 722, it did not make sense to me. I was like, what the fuck? Did they even raise the age? You have to look in the definition of a juvenile delinquent to actually see how they raise the age. Okay, so the way that they raise the age of criminal responsibility is that they made it so a 16-year-old as of October 1st, 2018, and a 17-year-old as of 2019 is not criminally responsible for anything other than a felony. So a 13-year-old is the same, murder in second degree or sexually motivated felony. 14 and 15-year-old is that same list about the robbery and all that crap. He's criminally responsible for that. But for our purposes, a 16-year-old who commits graffiti after October 1st is not criminally responsible.
Only a felony.
Only a felony. A 16-year-old who commits a felony, then he's an adolescent offender, and he will go to the youth park.
Correct me if I say something wrong.
All right, go.
Juvenile delinquent is 7 to 15 until October 1st, 2018.
Correct.
After that, a juvenile delinquent will be 7 to 16. If the juvenile delinquent is 16 and commits a felony, he will become an adolescent offender, 14 or 15, and commits a whole bunch of stuff between like machine guns and firearms. He will become a juvenile offender. Scenario, I'll just ask you, like, hey Mary, I know this kid, he's 14 years old and he committed manslaughter.
And we have to pretend that it's after October 1st.
What's gonna happen to him? Right. Or say, stealing a car would be considered what?
How old is the kid?
13.
Not criminally responsible. He's going to family court.
Right, only murder and sex.
He's a juvenile delinquent. Okay, welcome to 722. 722.0. All juvenile and adolescent offenders shall be notified of services through Probation Department. Probation Department conducts a risk and needs assessment, utilizing a validated risk assessment tool to help determine suitable programs and referrals. The participation is voluntary and kid may be accompanied by his lawyer at the assessment. Based on the assessment findings, the probation shall refer the kid to appropriate services. Nothing in this section precludes the probation department and the kid from entering into a voluntary service plan. When preparing the pre-sentence investigation report of any juvenile or adolescent offender, the probation department shall incorporate a summary of any assessment, findings, referral, and progress with respect to mitigating risk and addressing any needs. Probation shall not transmit or communicate to the DA any statement made by the kid to the probation officer. However, probation services may make recommendations regarding completion of a case plan to the youth part and provide information as it shall deem relevant. No statement made to probation may be admitted into evidence at a fact-finding hearing at any time prior to conviction. 722.10, Youth Part of Superior Court established. The fucking chief administrator is hereby directed to establish the youth part of the Superior Court. Judges presiding in the youth part shall be family court judges. Such judges shall receive specialized training, including but not limited to juvenile justice, adolescent development, care and custody of youths, effective treatment for reducing unlawful conduct by youths. Also, they have to get a backup magistrate who will be authorized to exercise criminal jurisdiction so that when the youth part judge is on vacation, that they're not sending it to regular arraignments. Unlawful conduct by youths make determinations in the power of the Superior Court. The youth part shall have exclusive jurisdiction over these proceedings. Alright, so I'm only doing this out of order so I can do the new section about adolescent offenders. And it's in 722.21. When an adolescent offender is arraigned upon an accusatory instrument in the youth part, the provisions of this section shall apply. If the part is not in session, they're brought to the most accessible magistrate, the person designated by the appellate division of the Supreme Court, to act in case the guy who normally does the youth part is not there. If the defendant waives a hearing upon the felony complaint, the court must order that the defendant be held to the action of the grand jury. If there be hearing, at the conclusion of the hearing, the youth part must dispose of the felony complaint as follows. A. If there is reasonable cause to believe he committed a felony, the court must order that the defendant be held for the action of a grand jury. So they could have done that in regular arraignment. I don't know what the fuck the point of this article is, really. Really don't know what the point of this article is so far. B. If there is not reasonable cause to believe he committed a felony, but there's reasonable cause to believe he's a juvenile delinquent, the court must specify the act or acts it found reasonable cause to believe the defendant did, and direct the action be transferred to the family court. C. If there is not reasonable cause to believe he committed any criminal act, the court must dismiss the felony complaint and discharge the defendant from custody if he's in custody or at liberty, or exonerate the bail if he's out on bail. Notwithstanding this, if he's charged with a felony other than a Class A felony, a violent felony, or a felony listed in paragraph 1 or 2 of subdivision 42 of 1.20, except as provided in sub C, the court shall, upon notice from the DA that he will not file a motion to prevent removal, order transfer of an action against an AO to the family court. Provided, however, that section 308.1 shall apply to actions transferred and shall not be considered removals subject to sub 13 308.1. I don't know what any of that says. I think if they went with a question on this test, you would have to know what the other charges are. So if the defendant is charged with a felony other than a Class A felony, violent felony, or if he's charged with any of those felonies listed in paragraph 1 or 2 of section 1.20 of the CPL. Honestly, I don't even think they could ask this question. I think it would be just too complicated. All right, but whatever, it's there. Notwithstanding 2 and 3, at the request of the DA, the court shall order removal of the action against an AO with an offense listed in paragraph A This is like horrendous. Okay. If the DA requests it, the court shall order this removal. However, where the felony complaint charges the AO with murder in the second degree, rape in the first, criminal sexual acts in the first, or an armed felony, rape in the first degree, murder in the second degree, criminal sex acts in the first degree, or an armed felony, a determination that such action be removed to family court in addition be based upon a finding of one or more of the following factors, and it's 3. 1 is mitigating circumstances. 2, defendant not sole participant, but his participation was minor, although not so minor, as to constitute a defense to the prosecution. Or 3, possible deficiencies in proof of the crime. The DA shall state upon the record the reasons for his consent, where such consent is required. Reason shall be stated in detail. 722.20. Proceedings upon felony complaint, juvenile offender. This is mostly similar. If the defendant is ordered to be detained, he or she shall be brought before the next session of the youth park. If the defendant is not detained, he shall be ordered to appear at the next session of the youth park. Oh, it just says the next session of the youth park. In both, whether or not he's detained. People walking by. If the defendant waives a hearing upon the felony complaint, juvenile waives a hearing upon the felony complaint, the court must order the juvenile be held for the action of the grand jury. If there is a hearing, at the conclusion of the hearing, the youth part must dispose of the felony complaint as follows. If reasonable cause to believe the juvenile committed a crime which a person under 16 is criminally responsible for. So we're talking about a 14-year-old or a 15-year-old who's charged with one of those really bad things. The court must order him be held for the action of the grand jury. If there's not reasonable cause to believe that they committed a crime for which a person under 16 is criminally responsible, but there is reasonable cause to believe the kid is a juvenile delinquent, the court must specify the acts it found reasonable cause to believe the defendant did and order the action be removed to the family court. If there is not reasonable cause to believe that the juvenile committed any criminal act, the court must dismiss the felony complaint, discharge the defendant from custody, and if on bail, exonerate bail. The court shall, at the request of the DA, upon consideration of the criteria in 722.22, criteria in 722.22, we say that 5 times fast, and if they determine it's in the interest of justice, they order removal of an action against the juvenile offense to the family court. However, if the kid is charged with murder in the second, rape in the first, crim sex acts in the first, or an armed felony, a determination must be based on one of these factors: mitigating circumstances, role in crime relatively minor, possible deficiencies in the proof. 5. If the felony complaint is pending and it hasn't been disposed of yet, and the defendant has not waived hearing and a hearing has not yet commenced, the defendant may make a motion to remove the case to the family court, pursuant to 722.22. So if the court orders removal to the family court and the DA consented, both of them have to state the reasons on the record in detail. Must state on the record the factors upon which its determination is based and give the reason for removal in detail. For the purpose of making a determination pursuant to sub 405, the court may make inquiries as deemed necessary. Any evidence which is not legally privileged may be introduced. So I think that means hearsay is okay. If defendant's testimony advised, they can only introduce his testimony to impeach. If the defendant testifies, his testimony may not be introduced against him in a future proceeding, except to impeach his testimony at future proceedings as inconsistent prior testimony. I'll wait. It'd be nice if I could do this in the fucking house. Where a motion for removal by a defendant has been denied, no further motion may be made for the same offenses. Where a motion is granted, there is no further proceedings against the juvenile. Alright, I'm going to skip ahead to, because I want to keep talking about the juveniles in one part. I don't want to skip around from between the adolescent and juveniles if I can avoid it. This is 722.22, and this is motion to remove the JO to the family court. So the procedure, after the kid makes a motion pursuant to 722.20, or after arraignment on an indictment, the court may, sua sponte or on motion of any party, order removal to the family court after consideration of these factors. Examine individually and collectively the following: seriousness and circumstances, extent of harm, evidence of guilt, history, character of defendant, effect of imposing upon the defendant a sentence authorized for the offense, the impact of a removal on the safety of the community, the impact of a removal on the confidence of the public in the justice system, when the court deems appropriate, the attitude of the complainant or victim, any other relevant fact indicating that a judgment of conviction in the criminal court would serve no useful purpose. That's my favorite one. The procedure for bringing a motion pursuant to this section shall be the same procedure as described in 210.45. After all the papers have been filed and submitted, the court must consider the same for the purpose of determining whether the motion is determinable on the papers submitted, and if not, may make such inquiry as it deems necessary for the purpose of making a determination.